Senator Bailey, for what purpose do you rise?
Thank you, Madam President. Would the sponsor yield for some questions?
The sponsor indicates he will yield. Senator Bailey.
Thank you. The bill outlaws assault weapon attachments from possession, from selling, from delivering, from purchasing. What is described as an attachment?
President Harmon.
Thank you, Madam President. I want to make sure I had the right definition to read. Senator Bailey, thank you for the question. Assault weapon attachment means any device capable of being attached to a firearm that is specifically designed for making or converting a firearm into any of the firearms listed in paragraph 1 of this subsection A.
Senator Bailey.
So a trigger, a bolt carrier, a stock, or a hand guard, all of which are attached to a rifle, are those considered an attachment?
President Harmon.
If they were to turn a weapon that is not covered by the definition into a weapon that is covered by the definition.
Senator Bailey.
All right, well, it's going to be interesting that with the discrepancy of that, if some of these parts break on firearms that are working, we're going to open up a whole new can of worms. Last summer, the Supreme Court, in deciding New York State Rifle Association and representing New York State Rifle and Pistol Association versus Bruen, said this: when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, and to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. The Second Amendment's text covers possession, practice, and acquisition as defined by the courts. So can you tell me what history and tradition from 1791 shows that commonly owned firearms were routinely banned from the average law-abiding person acquiring?
President Harmon.
Thank you, Madam President. I don't know exactly where to begin. First, the Supreme Court's jurisprudence on firearms is a bit muddled. They seem to have completely written out a well-regulated militia from their interpretation of the Second Amendment. Second, as we are all too acutely aware now, the Supreme Court jurisprudence can turn on a dime, so I wouldn't necessarily believe that the mess that is Supreme Court jurisprudence on Second Amendment issues will always be the same. And finally, I can say with confidence we are not including in our definition of an assault weapon any weapons that existed in 1791.
Senator Bailey.
To the bill, please.
To the bill, Senator.
I'm glad we find such an important situation in defending our nation hilarious. In 2008, the Supreme Court found that modern firearms are indeed protected by the Second Amendment. They said that some have made the argument, bordering on the frivolous, that only those in existence in the 18th century are protected by the Second Amendment. They said that we do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communications and the Fourth Amendment applies to modern forms of speech, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence in the time of our founding. Friends, you've got to know that the actions that you're taking right now are tyrannous, as my colleague Senator Bryant suggested. You also must know that I and millions of other gun owners in this state will not comply. And I fully expect and anticipate that our court will uphold this action and protect the rights of everyone in this country and everyone in this state.